have Gönenç Gürkaynak, founding partner of ELIG Gürkaynak Attorneys at Law in Turkey. And Gönenç regularly represents companies in high-profile cases before the Turkish Competition Board in antitrust investigations in all phases, including appeals of administrative decisions and before courts on private enforcement actions as well. Now, Gönenç has also authored various books and articles on contemporary competition law issues, both in Turkey and internationally. So it should be an interesting discussion.
Thank you very much. So very briefly, I'm going to engage in shameless but proud advertisement of an article that I had published in 2013 at the Journal of European Competition Law and Practice. This was of the Oxford University Press. This was an article that was discussing that an avalanche of enforcement in HR will come. And I was explaining why we have been thinking that HR is not going to be a hotbed of enforcement with the conditions of 2013, and saying why they're not applicable anymore. So let's wake up and smell the coffee. But then again, I was a guy from Turkey, and this was a very academic article, so I don't know how many people have seen it. It seems like not many HR people have seen it. And we are where we are. And what we were saying in this article was that buyer markets aren't getting enough attention for certain reasons that won't be applicable to HR markets anymore. And then we were doing a survey of all of the reasons articulated either by courts or by enforcement agencies or by academics as to why HR should be exempted from competition law enforcement as of 2013. Those have not changed. And those were, one, the net effect calculation is very difficult to do, so there should be deference. That's not applicable because the calculation methodology is there and there's more sophisticated use of complexity economics and general economics. Then there is labor law already, was one of the arguments. This is regulated by another field of law. It's not really a compelling argument. I'm not going to dwell on it. Labor markets are inherently competitive because they're so fragmented. Not so much. It has not been applicable for also reasons that we explain in this particular article. There is no consumer harm. This is still some debate, and some counsel use it as defense, sometimes credibly. So there isn't always consumer harm obvious, especially if it's an information exchange case that is of benchmarking the best practices kind of a nature. But then again, the burden of proof might be shifted to the defending party. There is the labor organizations protecting the rights of the employees anyway, so what's the big deal? These were the only observable reasons in academia or court decisions or decisions of enforcement agencies about why HR is so special. And in this article of 2013, we were saying these don't look very credible in and of themselves, in combination either. And now there are two factors that are going to change the landscape. One is the rise of the freelance, and that's going to lead to more attention. And two is the technology on the rise, which is going to lead to, which is already leading to the talent wars that were obvious in 2013. And we were saying there will be a peacetime for this war, and then that peacetime is going to attract competition law enforcement. So without taking any more of your time, back to you on what happened after 2013 and how the US got the lead in doing enforcement. There were some cases that we found in this article in Asia, by the way. The Singaporean authority had done one enforcement in 2011 and all that, but these were of wage fixing nature, most of them. The US, to us, has been the very first jurisdiction that went all out on all three phases of enforcement.
Gönenç, I know you pay close attention to developments elsewhere in the world. What are some of your observations from other jurisdictions?
Sure. Let me do a very quick round of what is happening in the Turkish jurisdiction, because it's actually one of the jurisdictions that takes on a lot of human resources related enforcement, and then do a very quick recap of what else is happening elsewhere in the world. Now, the Turkish Competition Authority has signaled that it is going to take HR matters seriously in the competition law sphere between 2019 and 2021. The first warning shot was their insertion of a note in the OECD report that the Turkish jurisdiction will move on into this sphere without any enforcement at that stage. Then in 2019, they came up with the BFIT decision, no poach in franchise agreements. And it said this would be an issue. But this time around, I'm asking for the removal of all non-compete obligations imposed on franchisees' employees. And I'll move away, but know that I will be enforcing. Then there was the 2020 last warning shot number 3, where in the container transporters decision, it said there is wage fixing and no poach here. Because of a very narrow geographical scope and because of the mitigating, redeeming virtues of the minimum wage regulations that are narrowing the effect here, I'm not enforcing again, but again, I am letting it known that I will move into this sphere. And then from now on, all of the decisions I will let you know about are also matters that I was involved in. I didn't choose the ones that I'm involved in, but as luck has it, in the HR sphere, all of the enforcement that they have done, I was defending. So in the hospital's decision, they came up with a decision that said there are other problems in terms of service fee fixing for freelance doctors and what have you, so quintessential competition law enforcement, but intertwined with it, there is a prevention of personnel transfers between hospitals. And this is my first enforcement on that kind of a matter. So this is a no poach, and here is your administrative monetary fine. So this was the end of the transitional period as of 2022. In 2021, there is no enforcement, also due to COVID matters. They were going after necessities quite a bit in Turkey. Then the HR investigation 1, as we call it, came in, which was solely standalone HR related. So it wasn't a market defined anymore. This was on HR matters. 32 undertakings from various sectors, their HR departments were raided, and 16 were fined, 11 of them settled, and some of them tried commitments. And the authority said, I won't accept commitments in the no poach territory. This is hardcore. Then HR2 came in 2024 in the IT sector. This started in 2022 when Israel was booming and the IT and technology sectors in Israel were attracting a lot of talent from the region, and Turkish IT people were flocking into Israel to work, which meant the remaining ones were being protected by the employers, and there were quite a bit of no poach arrangements in the IT sector, and the Turkish authority clamped down on it. Ultimately, it fined a lot of entities in that particular market. Again, in 2024, in the concrete manufacturer's case, a no poach arrangement enforced against. Then comes in the medicine investigation that is still underway. It's still going on. This is the peak of their enforcement in the sense that this time around they included human resource consultancy and employment agencies, the independent ones that do this as a profession into the scope of the investigation. And the crust of it is on the medicine sector, but also HR companies, headhunting companies, human resource consultancy services company, all of them, they're thrown into the mix in Turkey in terms of enforcement. One unexpected effect of all of this has come in the leniency applications in Turkey, because the leniency applicants started having second thoughts on doing leniency applications, because the Turkish Competition Authority is now so happy to do enforcement in human resources field that they're almost hijacking any investigation toward the human resources side as well. If they're downrating, and it's a very downrating authority, they're definitely rating the human resources side as well. So when a client comes in and says, we have all these, would you like to do an internal investigation? We would like to, burn our narrowly defined competitors. You tell them, yeah, well, you'll also be burning quite a bit of other people from other industries, because there's this WhatsApp group of your HR professional, and it's highly likely that when they get rated, this is going to be uncovered. And by the way, if you don't include this, then this is going to fall outside the scope of your leniency application. So how about it? Typically, the response is, let us think about this again, which is interesting because this wasn't an intended result of the toughening in the enforcement at the HR side. Very, very quickly, elsewhere in the world, there is ongoing legislation effort in Turkey, by the way, but I'm not going to talk about it. Basically, all that I have said is captured in a draft guideline that is being prepared in Turkey at the moment. There has been one level of consultancy on it. Elsewhere in the world, this is because of a recent article we have published, so I am quite up to date on what's happening where. In Australia, the ACCC is going after non-compete clauses and no-poach agreements with the Treasury per the request of the government. In Japan, there has been recent enforcement against Nippon Professional Baseball that was limiting athlete transfers. In China, in July 2023, there was a no-poaching agreement enforcement against 4 hog farming companies. In Mexico, there's a no-poach case in September 2021, 17 football clubs. In Peru, there is 6 construction companies regarding an alleged, still ongoing, no-hire agreement. This is still under review by Indecopi. In Brazil, the CAGI is looking into the healthcare sector. 35 individuals and 6 companies are being investigated for exchange of competitively sensitive information. This is coming from 2021 to date. These are the ones that I could find in my research where I was doing another take on the human resources field, enforcement in the human resources field. And there are, of course, other enforcement elsewhere, but I thought these ones might be interesting for all of you.